On behalf of the Moot Court Association of Government Law College, Mumbai, and the DM Harish Memorial Foundation, it gives us immense pleasure to welcome everyone present here today to the final round of arguments of the 24th DM Harish Memorial Government Law College International Online Moot Court Competition. We are honored to have amidst us Honorable Shri Justice Khata and Honorable Shri Justice Doctor, judges of the Bombay High Court, who will be presiding over the final round of arguments for today. We shall now commence with the final rounds.
Confirming if I'm audible and visible. I can't hear you, Your Excellencies.
Yeah, you may start.
Yeah. Thank you, Mr. President, and may it please the court. Your Excellencies, today I, together with my co-agent, represent the democratic nation of Gunterland, applicant in this case. I'll be addressing the court on issues A and B related to genocide and the 27 aircraft respectively for the first 15 minutes, while my co-agent will take the next 13 minutes to address questions C and D on citizenship and the validity of the arbitral award. We respectfully ask to reserve 2 minutes for rebuttal. The case before this court today relates to not one, but a series of internationally wrongful acts committed by the state of Parzival. It began by clandestinely dealing with a criminal fugitive from Gunterland to illegally expropriate foreign investment. It then went on to grant him citizenship, thereby actively frustrating its mutual assistance obligations. To validate its own illegality, it then invoked an abusive arbitral process. And finally, as a last desperate attempt, it is now before this court leveling false allegations of genocide. In my remarks today, I'll be making two broad submissions. First, that Gunterland is not guilty of committing genocide of the Sobrukai. And second, that Parzival has violated international law by assuming control of the 27 aircraft. If I may begin with my first submission. Your Excellencies, the Genocide Convention, extracted from page 1 onwards of our compendium, forms the customary international law on the subject. In order to constitute genocide, Parzival must prove that Gunterland has committed at least one of the 5 acts mentioned under Article 2 of the Convention. And in addition, Parzival must also prove the existence of a specific genocidal intent or the dolus specialis on part of Gunterland to destroy the Sobrukai group. Your Excellencies, we submit that Parzival's allegations are insufficient to prove either of these elements. First, on the actus reus question. In their memorial, Parzival has submitted that Gunterland's omission to investigate cases and provide resources in times of famines satisfies the material elements of paragraph A related to killings and paragraph C related to deliberately inflicting conditions of life calculated to bring about physical destruction, and the failure to investigate disappearances amounts to genocide under paragraph D under separation of sexes. Your Excellencies, in the limited number of cases that omission has been held to fulfill the material elements of Article 2, the accused himself had created the circumstances surrounding the omission, and the killings were directly attributable to the state. In particular, Your Excellencies, paragraph C of Article 2 of the Genocide Convention, which, as I said, is on the first page of a compendium, has been interpreted to mean subjecting a group of people to conditions of life such as a subsistence diet, systemic expulsion from homes, and a reduction of essential medical services. A mere failure to investigate or provide resources on part of Gunterland cannot be equated to state-orchestrated killings or subjecting a group of people to destructive conditions of life. And lastly, paragraph D, which relates to imposing measures intended to prevent births, has been invoked in the past in cases such as sexual mutilation, physical separation of sexes where the procreation becomes possible, or repeated sexual violence. There are simply no facts on record to support either of these actus reus elements. And therefore, on this ground alone, it can be held that Gunterland is not guilty of committing genocide of the Sobrukai. Unless your excellencies have questions on the actus reus question, I'll now proceed to the mens rea question. And while I submit that it is sufficient to disprove genocide on the basis of actus reus alone, we submit that even if I sense a concern.
No, continue.
We submit that even if one of the acts under Article 2 are made out, there is no proof of any specific genocidal intent on part of Gunterland. Respondent argues on page 2 of their memorial that Gunterland's pattern of conduct is sufficient to establish genocidal intent, and the same can be inferred from the general context of the situation and the repetition of discriminatory acts. Now, in the Bosnian genocide case, this court held that if reliance is sought to be made on a state's pattern of conduct, the chain of circumstances must be so impeachable, so conclusive, that the only hypothesis available is the evidence is an intent on part of the state to destroy a population group. Further, the UN Draft Convention of 1947 mentions that mere failure to provide resources, a mere lack of attention or negligence, even if it is reprehensible and even if it might amount to other human rights violations, cannot amount to an inference of genocidal intent. Your Excellencies, the starvation-related deaths that took place amongst the Sobrukai population in Gunterland were entirely contingent on uncertain natural events such as famines, and there is no regularity in the pattern of conduct by Gunterland. And therefore, even relying on the pattern of conduct test to infer genocidal intent, the high legal threshold of dolus specialis or a specific genocidal intent is not made out. In fact, to the contrary, respondents themselves submit on page 3 of their memorial that state policy is the first and the decisive test when it comes to establishing intent. It is on record that Gunterland has taken steps such as extending all equality laws to the Sobrukai people, upholding their cultural sovereignty, and acknowledging the historical injustices suffered by the Sobrukai people. And therefore, when the whole context of state policy and attitude is seen, there is simply no evidence, either direct or circumstantial, to attribute a specific genocidal intent to Gunterland. And therefore, we submit that this court should judge and declare that Gunterland is not guilty of genocide under customary international law, and in doing so, uphold the principle that allegations of a crime as serious as genocide cannot be thrown around for political reasons. If your excellencies have no questions on the first issue, I'll now turn to issue B.
Yes, carry on.
Your excellencies, Gunterland Airlines is the national air carrier of the state of Gunterland. In 2019, Gunterland Airlines had bought 30 new aircraft and stationed them in Parzival. In 2022, after purchasing 51% shares in Gunterland Airlines from Mr. Sorrento, Air Parzival assumed control of the 27 aircraft stationed in Parzival. Our simple case today is that this act of assuming control of 27 aircraft of another corporation, which is a foreign investment in your territory, amounts to a violation of international law. The respondents on pages 6 and 7 of their memorial have simply failed to address this question. Their entire case is that the contract of sale of shares from Mr. Sorrento to Air Parzival was valid, and that Air Parzival simply materialized, in their words, its investment under the shareholding. To be clear, we are not before this court challenging the validity of this contract. Our simple case before this court is that Gunterland Airlines, as a separate corporate legal personality, made an investment in the territory of Parzival by stationing its 27 aircraft, and by assuming control of these 27 aircraft, Parzival violated international law. In order to rebut this argument, respondents must respond to this submission of acquiring control of the 27 aircraft and not talk about the contract of sale of 51% shares, which is simply not our contention today or the question before this court. Now, in this respect, I'll be making two arguments. First, that the act of assuming control amounts to unlawful indirect expropriation under customary international law. And second, that the act also amounts to a violation of the fair and equitable treatment standard under Article 4 of the GPFTA. If I'm able to show to your excellencies that even one of these standards was violated by Parzival, that is enough to hold that Parzival has violated international law with respect to the 27 aircraft. Now, first on the expropriation point. Your Excellencies, under customary international law, indirect expropriation means depriving an investor of their use or economic benefit of their investment, even though he may retain nominal ownership. It is clear that by assuming control of the 27 aircraft, Parzival wholly deprived Gunterland Airlines from using its investment. Your Excellencies, in paragraph 70 of the Barcelona traction case, which is extracted on page 6 of our compendium, if Your Excellencies are with me, the case has been extracted on page 6 of the very short 15-page compendium which Gunterland has submitted.
Yes, ma'am. You are referring to?
Your Excellencies, the case of Barcelona traction, paragraph 70.
Yes.
Yeah. The highlighted part indicates that this court approved the principle of the separateness of the corporate personality and disapproved any genuine control test. In other words, this court has held in the past that a corporation such as Gunterland Airlines is an entity unto itself, and any concept of genuine control or effective link has not found acceptance in international law. Now, while it is true that Air Parzival owned a 51% shareholding in Gunterland Airlines, that did not give it a right to assume control of the assets of another corporation for its own purposes. And thus, this is a clear case of expropriation, and this is something the other side must address in their oral submissions today. Under international law, such an expropriation is invalid if it fails to fulfill even one of the conjunctive fourfold tests of public purpose, due process, compensation, and non-discrimination. Our submission is that Parzival's expropriation of the 27 aircraft was wholly arbitrary and unreasoned, without any notice, without showing any public purpose, and with no compensation whatsoever. And therefore, Parzival's acts amount to an unlawful indirect expropriation under customary law. Your Excellencies, while this submission is enough to hold that Parzival has violated international law, we also submit that Parzival has violated international law by breaching its fair and equitable treatment obligation under Article 4 of the GPFTA. Your Excellencies, under Article 4 of the GPFTA is available on page 10 of the moot problem, the compromise. Now, in Waste Management versus Mexico, which is extracted on page 8 of our compendium, again, the 15-page compendium, which has extracts of the primary sources we are relying on. If Your Excellencies are with me. In paragraph 8. Yes, Your Excellencies, page 8. It's the page numbers are on the top right corner of the compendium.
Yes, yes.
In paragraph 138, the tribunal held in Waste Management versus Mexico that a deliberate conspiracy between different agencies of the government to defeat the purpose of an investment agreement would lead to a violation of the FET standard.
Can I ask you a question at this point?
Yes, Your Excellencies.
Yeah, while you are referring to this judgment, before this, the circumstances were such that he had no choice but to move out because there was a scam which had broken out, right?
Yes, Your Excellencies.
To the scam, he had no choice but to move out of the country as the government agencies were really hounding him. So was there anything done to basically retrieve the... Yes. So therefore, what was being done to stop that, and what steps were government taking?
Your Excellency, the question...
Or he came to this situation where he had to travel out of the country and sell off the aircraft.
Your Excellencies, Mr. Sorrento was facing criminal investigations for serious financial crimes. And the state of Gunterland was taking steps under its domestic criminal process to prosecute him. Now, what has happened is Mr. Sorrento has escaped to Parzival, sold these 51% shares to Air Parzival, and under this 51% shareholding, Air
So
Parzival...
those are facts which we know, that he had sold off the shares. The question is, What did the government do to get back these shares from them?
Your Excellencies, the state of Gunterland does not contest today the sale of these 51% shares to Air Parzival. Our simple submission is that after acquiring these 51% shares, Air Parzival could not have taken away the 27 aircraft, and that amounts to a violation of international law.
Okay, carry on.
Yeah. Our submission on the FAT standard is simply that there was a deliberate conspiracy between the Parzival's Ministry of External Affairs and the Ministry of Civil Aviation. They first conducted a deal with the fugitive criminal, then announced the acquisition of the 27 aircraft, gave him citizenship in merely 48 hours. And then, if lastly I may refer your Excellencies to page 16, paragraph 27 of the problem, when Gunterland objected to Parzival's acts, Parzival stated, quote, "Since when did international law begin dictating corporate business ethics?" Your Excellencies, this series of events, and particularly its last statement, shows clearly that Parzival utterly disregarded its obligations under the GPFTA and thus violated international law. For all these reasons, we pray that this court declare and adjudge that Parzival has violated international law with respect to the 27 aircraft. Thank you very much. It was an honor to argue before this bench.
Thank you.
May I begin, Your Excellencies?
Yes, please continue.
Thank you, Mr. President, and may it please the court. In an international rules-based order, a state cannot use its sovereign right to shield acts which reek of bad faith and cause injury as a result of them. And surely an arbitral process under international law cannot be used to justify its own infractions of the rule of law. In my remarks today, I will be making two broad submissions. First, that Parzival has abused its rights and duties under international law in granting Mr. Sorrento with citizenship. And secondly, the arbitral award obtained by Parzival is liable to be set aside on the grounds of nullity. Beginning with the first submission, Your Excellencies, Mr. Sorrento was being investigated for serious financial crimes by Gunterland. Being aware of this, Parzival's Ministry of External Affairs declared that it will observe any requests made by Gunterland for the purpose of the enforcement of its domestic criminal laws under the Ogden Crime Cooperation and Prevention Treaty. In the meantime, Mr. Sorrento sold his stake in Gunterland Airlines to Air Parzival at 1/10 of the price. And within 2 days, he was granted expedited citizenship by Parzival. And finally, in another 2 days, he escaped to Raidin, from where he could not be extradited by Gunterland. In this regard, I submit two things. First, Parzival has abused its rights in granting citizenship to Nolan Sorrento. And second, it has violated its duty of good faith to uphold its treaty obligations under the Ogden Treaty. Your Excellency, the other side has elaborately argued on pages 10 and 11 of their memorial that each state reserves the sovereign right to grant citizenship under its own domestic laws to any individual that it deems fit. Gunterland has not submitted that this right is in dispute. It is our submission that under Article 1 of the Hague Convention on Nationality Laws, it is stated that this law shall be recognized by other states insofar as it is consistent with international conventions, international custom, and the principles of law generally recognized with regard to nationality. This implies, Your Excellencies, that in case of a dispute between two states on matters of citizenship, the grant of citizenship must be shown to be in conformance with general principles of international law. One such principle, Your Excellencies, is the principle of abuse of rights, which finds its roots in the good faith requirement in Article 2, Clause 2 of the UN Charter, which has been extracted on page 10 of our compendium. A country is said to have abused its rights if it exercises that right in an arbitrary or unjustified manner, thereby causing injury to another state. In the present case, Your Excellencies, if you may refer to para 5 on page 7 of the record, if Your Excellencies are with me, Sorrento was granted citizenship under Clause D of the immigration laws of Parzival. Yes, Your Excellency.
What are you reading?
The immigration laws extracted on para 5 on page 7 of the record. Page 7 of the problem, Your Excellencies. In any case, Your Excellencies, I'll be reading out the provision in my speech. May I proceed?
Yes. Yes, please proceed.
Yes, Your Excellencies. Under Clause D of the immigration laws, Mr. Sorrento was provided citizenship for his extraordinary contributions to Parzival's economy. While it is true that the Parzival Ministry of External Affairs under Clause E has the complete authority to make any exceptions to the immigration laws of Parzival, it is also true that these exceptions were very rarely made in practice. Your Excellency, the other side has defined arbitrariness as a mere disregard of procedure. However, we submit that it cannot merely be limited to that. In the case of LC, United States versus Italy, this court has opined in para 28, and I quote, arbitrariness is not so much something as which is opposed to a rule of law as something opposed to the rule of law. This idea was expressed by this court in the asylum case when it spoke of arbitrary action as a substitute for the rule of law. It is a willful disregard of the due process of law, an act which shocks or at least surprises a sense of juridical propriety. Your Excellencies, in the current case, Parzival, while being fully aware of the criminal investigations underway against Sorrento, made a declaration affirming cooperation to Guntherland for its criminal investigations. And yet, it went ahead to hold a covert high-level meeting with a fugitive who was underground in its territory. It struck a deal, and merely within a matter of 48 hours of striking that deal, it granted Mr. Sorrento with expedited citizenship. This was done in return for buying his shares at 1/10 of the price. Thus, it is submitted in view of these special circumstances and the manner of granting citizenship that Parzival has abused its rights by using them in an arbitrary and unjustified manner. On the damage point, Your Excellencies, a perusal of para 19 of the compromise would show that Mr. Sorrento was operating on huge loans on the back of illegal gratifications, quid pro quos, and underhanded payments made to banks in Guntherland. Para 13 clearly states that Sorrento's entire empire was entrenched in Guntherland's economy. Moreover, the Supreme Court of Guntherland in para 20 conclusively ordered Mr. Sorrento to repay all his debts. In light of these circumstances, the allegation made by the other side that the damage was merely incidental and is not sufficient to prove abuse of rights stands unfounded. It is our submission for these reasons that Parzival has abused its rights under international law.
Madam, could you tell us that if a party was offering them shares at 1/10 of the price, how is Parzival concerned as to what is the price? Why should it pay more when it is being offered at 1/10? And was it the government of Guntherland offering the shares at a higher price? In fact, there were cases against this gentleman, and therefore he had to move out. And whatever price he offered, he wanted to collect the price and move out. So how do you defend yourself?
Your Excellency,
What to say about it?
In response to this, it is not our submission that merely selling the stake at the price of peanuts was the reason because of which Parzival has abused its rights. The reason of the abuse of rights is the fact that first it made a statement affirming cooperation to Guntherland in its criminal proceedings against Sorrento, and later went back on that statement and granted citizenship by masking it under the mere procedural technicality of granting citizenship to Sorrento for his extraordinary contributions. The point is that this was done within a matter of 2-3 days, when usually this took 6 years when usually these applications took years to get processed. As a result, this indicates a clear bad faith on part of Parzival, and hence an abuse of rights can be imputed to them. May I proceed?
Yes, proceed.
Thank you, Your Excellency. Since there's a paucity of time, I would like to move on to issue D now. In this regard, Your Excellency, we have two broad submissions to make. Firstly, that this court has the requisite jurisdiction to entertain the challenge to the arbitral award. And secondly, that the award is liable to be set aside on the grounds of nullity. At the outset, Your Excellencies, I would like to make it clear that the other side has argued that the New York Convention must be applicable in the present case. However, Article 5 of the New York Convention, which the other side has relied on, only comes into force when the proceedings are regarding enforcement. When the winning party to an arbitral award seek to enforce an arbitral award in the territory, in the domestic courts of the losing party, that is when Article 5 comes into picture. However, here, the challenge is merely being made to the validity of the arbitral award and on grounds of nullity. The challenge has been brought by Guntherland on these grounds of nullity, and hence Parzival must respond to these grounds to show that the award is invalid. Moving on to the first submission, Your Excellency. The present dispute has been brought before this court under Article 40, Clause 1, read with Article 36, Clause 1 of the ICJ statute by way of a special agreement, which is the compromise in the present case. Moreover, under customary international law, certain grounds to challenge an arbitral award of the fundamental grounds of nullity have been enumerated. These grounds include an excess of powers by the tribunal, corruption, failure to give sufficient reasons, a serious departure from a fundamental rule of procedure, or the nullity of the compromise. These rules have also been extracted on page 15 of the compendium for your perusal. Your Excellency, in its award dated 1st July, the tribunal passed a twofold relief in favor of Parzival. We submit that this award is a nullity on the ground of excess of powers in two ways. Firstly, with regard to the relief related to the 27 aircrafts, we submit that the tribunal decided on an issue that was not raised before it. Parzival, under para 28 of the problem, initiated the arbitral proceedings in response to Guntherland's actions of nationalizing the 51% shares. There is no mention whatsoever of the 27 aircrafts. In fact, it is highly unusual in international investment arbitration for a host state to approach a tribunal seeking a declaration that it has not violated the terms of the agreement. In fact, to the best of our knowledge, there exists no case in international arbitration practice to suggest the same. Hence, the tribunal exceeded its powers in passing an award on an issue that was not raised before it. On the second point, Your Excellency, with regards to the 51% shares, we submit that the tribunal exceeded its powers because it entertained a party whose own actions were tainted with illegality. According to the doctrine of unclean hands, a tribunal will not entertain a party whose own cause of action is based on an unlawful act. In the case of World Duty Free Coal Limited versus the Republic of Kenya, for instance, the investment tribunal held that a tribunal must refuse to hear a claim based on a contract that is obtained through corruption. In the present case, the 51% shares were acquired by Parzival in return for surreptitiously granting Mr. Sorrento's citizenship, which was on a quid pro quo basis as a bribery. As a result, since the subject matter of the claim was itself tainted with corruption and illegality, it is submitted that the tribunal did not have the jurisdiction to pass an award on this issue. For these reasons, Your Excellencies, we respectfully urge this court to adjudge and declare that the award dated 1st July 2022 is a nullity under international law and on the ground that the tribunal exceeded its powers in passing both the reliefs. Thank you for the patient hearing. It's been an honor to argue before this court.
Thank you. Thank you.
Your Excellencies, am I audible and visible?
Yes.
Much obliged. Honorable President, Your Excellencies, may it please the Honorable Court. I'm the first agent representing Teen Court P on the behalf of the Sobriquet Republic of Parzival in the matter concerning the disputes that have arisen in the Ogden region. Your Excellencies, the disputes that have arisen have led to the formation of 4 questions pertaining to the essence of international law. And over the next 15 minutes, I seek to address issue number 1 and issue number 3, dealing with the fixing of the international responsibility for the crime of genocide and the conferral of nationality to Mr. Sorrento, respectively. My co-agent shall be addressing issue number 2 and issue number 4 in the remaining 15 minutes of this court's valuable time. Your Excellencies, may the agent proceed with providing a brief encapsulation of the facts?
Yes.
Much obliged, Your Excellency. The 2 countries in the Ogden region, Gunterland and Parzival, have strained relations owing to the history going back to the European colonization and the subsequent independence of Parzival from such atrocities committed by the European colonization and the formation of a haven state called Parzival for the Sobriquet. Parzival formulated strict citizenship laws in favor of the Sobriquet and accused Gunterland of committing genocide in its territory, which shall be proved by the agent in the present case, Your Excellency. To ease the relations, a free trade agreement was signed between both the countries. Further, the privatization of Gunterland Airlines led to a dispute as the managing investor, Mr. Sorrento, sold the majority stake to Parzival. This strained the relations, inviting an arbitration before the Permanent Court of Arbitration and culminating into the present dispute before this honorable court. If Your Excellencies are satisfied, may the agent proceed?
Yes, please.
Much obliged, Your Excellency. The agent, by way of her submissions, strives to prove the voidness of all allegations levied by Gunterland and to prove the guilt of the applicants in the following case. Your Excellency, moving with the first submission at hand, the term genocide, as coined by the Polish Jewish lawyer Raphael Lemkin, invokes the set of horrors that were experienced during the Holocaust. Your Excellencies, the submission before this court in this regard is that Gunterland is guilty of committing genocide of the Sobriquet in its territory, and the same shall be dealt with in a set of threefold arguments, consisting of proving the dolus specialis, that is the specific intent, and proving the actus reus, that is the physical element, and lastly, proving the state policy of Gunterland in this case. If I may invite the attention of Your Excellencies to page 1, citations 3 and 4 of the written submissions. Are Your Excellencies with me?
So page 1, right? Page 1?
Page 1,
Yes.
citations 3 and 4 of the written submissions, Your Excellency.
Yes.
Much obliged, Your Excellency. The obligation of states with regards to genocide as per the Genocide Convention is both preventive and punitive in nature. Further, the customary obligation is not only of preventing genocide, but that of not committing genocide as well. Gunterland has been in the violation of the 3 obligations of not committing, punishing, and protecting its population by way of being involved in the disappearance and murder of over 6,000 Sobriquet women, which constitutes the omission to prevent genocide. Further, Gunterland failed its duty of preventing genocide by not providing relief and assistance to Sobriquet during the years of uncertain climate, which led to tens of thousands of only Sobriquet deaths, Your Excellency. If I may emphasize more on the fact that there were only Sobriquet deaths. Moving to the second,
Can I just ask you a question here? When you are saying so, that is there any proof of this particular fact that they have committed this? And
Much obliged.
have you filed any case? Have you filed any case or proceeding against the other side?
Much obliged, Your Excellency. Your Excellency, the present case is indeed in the same regard before this court. And if I may invite.
You were not the claimants here.
Much obliged.
You
Your
all are
Excellency.
the parties who had gone to arbitration. It was Gunterland who went for arbitration, right?
Much obliged, Your Excellency. It was Parzival that went for arbitration while Gunterland did not show up for the arbitration.
Very well. Thank you.
May I proceed, Your Excellency?
Yes, please continue.
Much obliged. Your Excellency, if I may direct your attention to page number 9, para number 8, pointers number A, B, and C of the compromise. Your Excellency, page number 9 of the compromise, that is the special agreement. Are Your Excellencies with me?
Where did you get this? Page number 9. This one. Yes, please carry on.
Your Excellencies, the violation of the 3 obligations of not committing, punishing, and protecting that have been violated by Gunterland can be noticed by way of clauses A, B, and C of paragraph number 8, Your Excellency. Moving to the second limb of my argument, the agent seeks to establish that Gunterland committed genocide by way of a threefold argument involving the establishment of the intent or dolus specialis in this case. Your Excellencies, this very honorable court in the Bosnian genocide case laid out a 3-test approach to determine genocide, which can be summarized as firstly, intention manifested through a concerted plan. Secondly, intention inferred from a consistent pattern of conduct. And lastly, intent ascribed by the articles on state responsibility. Your Excellencies, Gunterland acted in accordance with its concerted plan of perishing the sobriquet, and the existence of such a plan can be highlighted by way of the clauses that Your Excellencies was just directed to. Moving to the second element of a consistent pattern of conduct. In this light, it is very important to underline the actions of the European settlers or the ancestors of the erstwhile Euro-Gunterland society, which were the founding stones of the genocide that has been occurring over the years in the territory of genocide over the years, beginning in the 14th century and moving on to the years of 1999, 2007, 2013, 2017, and 2019. Your Excellencies, the third and final test of ascribing intent using articles on state responsibility is being dealt with in a 2 sublimbs manner. That is, firstly, Gunterland's conduct amounts to an internationally wrongful act, and the same is attributable to the state of Gunterland. Moving to the first sublimb of my argument, Your Excellencies, Article 15 of Articles on State Responsibility considers a series of composite actions and omissions constituting an international wrong sufficient to fix responsibility. As was reiterated in the Tehran case by the International Court of Justice, that the responsibility of Iran was entailed by the inaction of its authorities, which failed to take appropriate steps. Your Excellency, it is indeed shameful that in today's age of erga omnes obligations and responsibility to protect the general populations, the applicants are absolving themselves of the responsibility of protecting tens of thousands of sobriquets and leading to their deaths, Your Excellency, on the pretext of not directly killing them. Your Excellency, it is to be noted, as mentioned by the learned opposing counsel, that omission also accrues state responsibility, and it is argued that it was the omission of Gunterland's instrumentalities to protect the population from dying during uncertain times for 2 decades, and further their omission to investigate such acts, which constitute state responsibility under Article 4 of the Articles on State Responsibility, which is customary in nature by way of the Bosnian genocide case, Your Excellency. Moving to the second limb of the argument towards determination of genocide is actus reus, that is the physical element. The Article 2 of the Genocide Convention lists down 5 acts that constitute the crime of genocide. Your Excellency, before I begin with my arguments, it is very important to highlight the fact that my learned opponents have themselves agreed that the target population must be emblematic. And further, in the Bosnian genocide case, it was held that the 8,000 men were of military age and was significant for the community. Your Excellency, in this present case, the 6,000 women that were separated from the general population of Sobrukai were going to give birth to more Sobrukai, and and their discriminatory separation from the rest of the group to prevent births within the group is very pertinent to be noted over here, which constitutes an act of genocide under Article 2 of the Genocide Convention, clause number D, Your Excellency. Further, moving on, Your Excellency, the agent on further research begs to make some modifications in particular submissions so as to ensure justice for the respondents. The concept of cultural genocide, even though not codified in international law, but recognized by the founder of the word genocide, Mr. Raphael Lemkin, and the United Nations Ad Hoc Genocide Committee, Your Excellency, remains a major evidencing factor in for the elements of mens rea and actus rea, as was recognized in the Christic case. Where there is physical or biological destruction, there are simultaneous attacks on the targeted group's cultural and religious property, which evidences the purpose to physically and biologically destroy the group. Your Excellencies, if I may invite your attention to page number 9, para number 8, point number C of the compromise. Are Your Excellencies with me?
Yes.
Much obliged, Your Excellency. In the present case, such an evident factor which cannot be ignored is the preferential manner in which the Euro-Gantelan society is promoted, and the schooling or propagating systems of the sobriquet are targeted by means that intend to restrict such teachings and promotion of their culture. Thus, Your Excellencies, it can clearly be seen how both the elements of mens rea and actus rea are satisfied in the present case. Moving to the last element of the state policy of Ganteland in this case, the agent seeks to establish before this court that the Darfur Commission very rightly held that the state policy is decisive when it comes to the crime of genocide and determining the international responsibility of a state in this case. Further, following the inferential principle in this case, the policy of dismantling the sobriquet culture by prohibiting sobriquet language and religion, followed by the omission of the duty of Ganteland to provide aid and investigate the disappearances and murders of the sobriquet women, proves the existence of a mental, physical, and policy-based elements and establishes the crime of genocide, Your Excellency. With the permission of Your Excellencies, may the Council proceed with the next issue, that is the third issue.
Yes, please.
Much obliged, Your Excellency. Your Excellency, the agent submits that before this court that Parzival did not abuse its rights and duties under international law in providing Mr. Nolan Sorrento with citizenship, and the same shall be dealt with in a twofold manner. The first argument under this main submission is that nationality is a sovereign matter immune from foreign interference as derived from Article 2 of the UN Charter. The determination of nationality by a state is concomitant of state sovereignty. Your Excellency, if I may invite your attention to page number 10, citation number 68 of the written submissions. Are Your Excellencies with me?
Just a moment.
Your Excellencies, page number 10, citation number 68.
Yes, please.
Much obliged, Your Excellency. Your Excellency, as can also be referred by way of page number 63 of the compendium, it was declared by this very honorable court in the nationality decrees issued in Tunis and Morocco that questions of nationality are in the reserved domestic domain of a state, and such rights can only be circumscribed in cases where the state is committing internationally wrongful acts by depriving a national of its nationality, discriminating on the basis of gender and race of a person, or rendering an individual stateless by denationalization, none of which was exercised by the Federal Republic of Parzival. Moving to the second fold of the main submission, the agent in arguendo seeks to establish before this court that Parzival did not abuse its rights or duties, and the argument shall be dealt with in a threefold manner. Your Excellency, before moving on with the submissions with this issue, the agent seeks to establish that the second counsel on the behalf of the applicants has misled the court by quoting a blatantly false fact If I may invite your attention to page number 14, para number 20 of the Moot Compromise, Your Excellency.
Yes.
Are Your Excellencies with me?
Yes, carry.
Much obliged, Your Excellency. Your Excellency, you can clearly note over here that the Supreme Court of Gunterland did not order Mr. Sorrento to repay all his debts and initiate appropriate criminal proceedings. Rather, Your Excellency, the Anti-Corruption Bureau of Gunterland had approached the Supreme Court. Your Excellency, it must be noted in this regard how the applicants on behalf of Gunterland have misled this court by quoting a completely false fact that does not exist. Your Excellency, in order to summarize the entire submissions of this issue, the agent seeks an extension.
Yes, okay.
Much obliged, Your Excellency. Your Excellency, following the above line of argumentation, I shall begin with the first limb of my argument, which is that Parzival did not abuse its right. An abuse of right can be constituted when there exists an arbitrary or discriminatory conduct on the behalf of the state. Exercise of any right is considered arbitrary if it inflicts damage on the other parties without serving any apparent legitimate purpose and is not based on legal standards but on discretion or prejudice. The conferral of Parzival was not an abuse of its sovereign rights, as discriminatory intent flowing from a differential treatment owing to a particular being from a racial or ethnic or a gender basis cannot be established. Further, the arbitrariness of such an action cannot be inferred as the conferral was made in accordance with the citizenship laws of Parzival. Moving to the second limb of the argument, Your Excellencies, it is implored before this court that there was no violation of the duty of non-intervention. Your Excellency, a responsibility for such an action can be invited under Article 8 of the Articles on State Responsibility. Customarily, two sorts of interventions are recognized. Firstly, direct intervention, and secondly, indirect intervention, which constitute of promoting force, armed insurgency, instigating or controlling some actions or behaviors in the other state. However, Your Excellency, in the entire special agreement that has been filed before this court, nowhere can it be noted that any subversive behavior was promoted by Parzival in the state of Gunterland. Lastly,
Madam, just before you go to the last point, on what basis have you granted him citizenship in 4 days' time? Or rather, was it a matter of vengeance because of which you did this? Is that what your government wanted to do in view of all the atrocities that you claim that was done on Parzival by Gunterland?
much obliged, Your Excellency. The agent indeed.
What is the justification?
Much obliged, Your Excellency. The agent indeed begs
I
to
hope
differ.
you got our point, right?
Yes, Your Excellency.
I hope you understood our point.
Yes, Your Excellency. Your Excellency, the citizenship was conferred upon Mr. Sorrento by way of the citizenship laws of Parzival that have been codified in paragraph number 5, page number 7 of the Moot Compromise. Under these clauses, clause number D and clause number E were the ones that were in force that provided citizenship to Mr. Sorrento. Secondly, Your Excellency, by way of the special agreement, it can clearly be highlighted that the citizenship was conferred upon Mr. Sorrento due to his economic gratification and contribution to the economy of Parzival, Your Excellency. Lastly, Your Excellency, my last limb of the argument shall satisfy the further doubts with regard to this question, if the agent may be allowed to proceed.
Yeah, just a moment.
Why was this done in 48 hours when you yourself point out that applications for citizenship normally take a year to proceed, to be processed?
Much obliged, Your Excellency. Your Excellency, indeed, this can be noted by way of clause number D of the citizenship laws. However, Your Excellency, if I may direct your attention to clause number E of the citizenship laws of Parzival, the Parzival's Ministry of External Affairs had complete authority to make any exceptions to the immigration laws that they deemed fit. And this was a sovereign matter, immune from foreign interference, as was held by this very honorable court in the nationality decrees issued in Tunis and Morocco, Your Excellency. May the agent proceed, Your Excellency?
Yes.
Yes, please continue.
Much obliged, Your Excellency. Lastly, the agent seeks to establish that Parzival performed its duties in good faith. The good faith principle precludes any act defeating the principles of a treaty in force, as against the claims of the applicants. The respondents acknowledge the principle of pacta sunt servanda, codified in Article 26 of the Vienna Convention on Law of Treaties, which is also customary in nature, Your Excellency. Parzival's unilateral declaration to observe any requests made by Gunterland to enforce its domestic law underpins the exercise of the Ogden Treaty in good faith, as against the claims of the applicants who say that we provided citizenship to a fugitive, which is not proven yet, as these are mere allegations that have been levied against Mr. Sorrento. Secondly, Your Excellency, in this regard, it is very important to note that the unilateral declaration regarding observing the domestic law of Gunterland in the state of Parzival was indeed made by the state of Parzival, which the state of Parzival is very well aware of the fact that the unilateral declaration is binding on the party that makes it by way of the nuclear tests case that was decided by this very honorable court. However, Your Excellency, it is very pertinent to note that Gunterland did not make any such requests towards Parzival to either hand over Mr. Sorrento to him or to initiate any proceedings in the state of Parzival against Mr. Sorrento. Your Excellency, the frivolous claims made by Gunterland claiming the violation of Ogden Treaty by Parzival falls short of substance, given the fact that a declaration was made and no requests were made by Gunterland. Your Excellency, in this light, it is humbly submitted by the agent on behalf of Parzival that there was no abuse of rights and duties under international law by conferral of nationality to Mr. Sorrento. Your Excellencies, it was an honor to plead before this court. I hand over the case to my co-agent.
Yes, please.
Your Excellencies, if I may just be given 10 seconds to start.
Yes, you may start.
Your Excellency, shall I start?
Yes, please.
Much obliged, Your Excellency. Mr. President, Your Excellency, I shall continue the submissions for the respondents in the case of the Democratic Nation of Gunterland versus the Federal Sobriquet Republic of Parzival. And during the course of my time, I shall primarily be dealing with two issues concerning the violation of international law by the state of Parzival for assuming control of the 27 aircrafts stationed in its territory, and the challenge of the arbitral award by the state of Gunterland before the ICJ. With Your Excellency's permission, the agent would proceed towards the second issue.
Yes, please.
Much obliged, Your Excellency. The second issue before this honorable court, Your Excellency, is that Parzival has not violated international law by assuming control of the 27 aircraft stationed in its territory. And Your Excellencies, the submissions in this regard are all interconnected and in fact form a circle. In sum and substance, Your Excellency, the agent will firstly establish as to how Mr. Sorrento is the effective owner of Gunterland Airlines, and he also exercises effective control over the airlines. Your Excellency, when he is the owner and has effective control over Gunterland Airlines, he has the right to enter into a contractual agreement with the state of Gunterland. And Your Excellencies, when he has entered into a contractual agreement with the state of Gunterland, with the state of Parzival, Your Excellencies, then subsequently it becomes an investment of the state of Parzival, and Parzival has the right to materialize that investment, Your Excellencies. At this stage, the agent seeks the permission of Your Excellencies to proceed with the limbs of the contention.
Yes, please.
Much obliged, Your Excellency. Your Excellency, the first limb of the argument is that Mr. Sorrento is the owner and has effective control over Gunterland Airlines. Ownership is based on shareholdings, Your Excellency. Mr. Sorrento has the majority shareholding of Gunterland Airlines, which is in fact determinative and sufficient, Your Excellencies, as per the case of Aguas, para number 264 of the judgment, and Your Excellencies may be pleased to refer to page 92 of the compendium submitted, Your Excellencies. Are Your Excellencies with me on this?
Just a moment, I'll give it up.
Indeed, Your Excellencies.
Paging 29 and goes again to.
Yes, please carry on because we can't find that page 90. It's not page. It's not paginated properly, but nevertheless, carry on.
Much obliged, Your Excellency. Your Excellency, furthermore, Mr. Sorrento also has effective control over Gunterland Airlines, as control is validated by the fact that some activity of investing is required, which has been done in the instant case, Your Excellency. Furthermore, voting rights and the legal capacity to operate indicates control. Your Excellencies, as per page 12, para number 14 of the compromise, and Your Excellencies may refer to it, page 12, para number 14 of the compromise. Are Your Excellencies with me on this?
Yes.
Your Excellency, Mr. Sorrento was the board chairman and also has veto powers over the buying and the selling of the aircrafts, which is in fact, Your Excellency's determinative of effective control over Gunterland Airlines. Your Excellencies, when Mr. Sorrento has the effective control over Gunterland Airlines, in fact, Gunterland Airlines is a private entity, Your Excellencies. As per para 14 of the compromise, it has been stated that Mr. Sorrento has a controlling stake in Gunterland Airlines, and he also has effective control over Gunterland Airlines. So, Your Excellency, Gunterland Airlines is not a state-owned enterprise, which can also be corroborated from a decisive Brochus test, which laid down the functions criteria, Your Excellency. And Your Excellencies, in the functions criteria, it was laid down that an entity is a state-owned entity only if it performs a primarily governmental function. And Your Excellencies, aviation cannot be considered as a primarily governmental function as it is a commercial function, Your Excellencies. So it is not a state-owned enterprise. So the entire argument of the applicants about expropriation does not hold ground, as there has been no deprivation of the property and the ownership of the state of Gunterland, as effective control has been exercised by Mr. Sorrento in the instant case, Your Excellency. Furthermore, expropriation, if at all happened, is not unlawful in the instant case, as for an unlawful expropriation to take place, the expropriation must be malified and it must be illegitimate. But for the state of Parzival...
Sorry, can I just interject and ask you a question? That if you are saying that it is not illegal, the point we are making is that was Parzival not aware of these scams which had broken out with this particular person, Mr. Sorrento?
Your Excellencies, the humble submission in this regard is that it is the cardinal principle of criminal law that a man is innocent until proven guilty. So there were some investigations which were going on in the state of Gunterland, Your Excellencies. However, there was no decisive decision issued by the Supreme Court of the state of Gunterland, and hence there were mere accusations, Your Excellency, and nothing was proven.
Then why did he want to sell off the entire stake at 1/10 of the price?
Your Excellency, the humble submission...
Wasn't it giving rise to suspicion?
Your Excellencies, the humble submission in this regard is that the actions of Parzival have been bona fide, as it was a negotiation arrived between Mr. Sorrento and the state of Parzival, and negotiations take place with regard to price in a contractual agreement, Your Excellency. So it was a mere negotiable discussion which took place, Your Excellencies, and not warranting the violation of international law, Your Excellencies, in the instant case.
No, but if you see the citizenship granted was within 48 hours, how would you defend that?
Indeed, Your Excellencies, as already argued by my co-agent, it has been argued that the MEA can make extraordinary exceptions in the citizenship laws, Your Excellency. And for his extraordinary contribution to Air Parzival, in fact, Mr. Nolan Sorrento was granted citizenship, and it is the sovereign domestic affair of the state of Parzival, Your Excellency, precluding any kind of foreign interference.
What my brother judge was asking is that given both the circumstances of the reduced price, the expeditious manner in which the citizenship was granted, weren't those compelling and extraneous circumstances which gave rise to suspicion?
Your Excellencies, the humble submission in this regard is that, in fact, the state of Parzival's bona fide can be proven by a unilateral declaration which was made by the state of Parzival that it will observe any request made by the state of Gunterland to enforce the Ogden Crime and Cooperation Treaty. However, no such request was made, Your Excellency, and hence Parzival's bona fide can be proven in this regard, Your Excellency. May I move to my further submissions, Your Excellency?
Yes, please carry on.
Much obliged. Your Excellency, when he is the owner and has effective control over Gantaland Airlines, he has every right to enter into a contractual agreement with the state of Parzival, as the contractual agreement was entered in his private capacity and not in the sovereign capacity of the state of Gantaland, and hence the agreement would be governed by the domestic laws of the host country, which is the country of Parzival in the instant case, Your Excellencies. If Your Excellencies have no preliminary objections at this stage, the agent would proceed towards the next limb of the contention.
Yes.
Much obliged, Your Excellency. With the contract signed between Mr. Nolan Sorrento and Parzival, it subsequently became an investment of the state of Parzival, satisfying the Salini test. The Salini test very decisively was held in the case of Salini versus Morocco, and it laid down 4 criteria to determine an investment. Firstly, there has to be a contribution in the form of money and assets. Secondly, the contribution must be for a particular duration. Thirdly, it must possess a certain risk. And fourthly, Your Excellency, there also has to be a contribution to the development of the host state. In the instant case, the humble submission is that all the 4 criteria are being satisfied, as Parzival invested in the airlines. Secondly, it boosted the economy of the state of Parzival, as Air Parzival was made lucrative. Thirdly, the investment was long-term in nature, as Parzival subsequently materialized the investment, Your Excellencies. And this can be deduced by page 14, para number 21 of the compromise as well, Your Excellencies. Are Your Excellencies with me on this?
Yes, please carry on.
Much obliged, Your Excellency. Moving on to the third limb of the second issue. Article 2 of the United Nations Charter, Your Excellencies, categorically reaffirms the concept of sovereign equality of all its members, precluding any kind of foreign interference, as Article 2, Clause 4 of the United Nations Charter emphasizes upon the political independence of states. So, in its sovereign capacity, Your Excellencies, the control of the 27 aircrafts was assumed by the state of Parzival, as already the 51% stake was sold by Mr. Nolan Sorrento to the state of Parzival via a contractual agreement signed between the two parties. At this stage, cumulatively it is submitted that Parzival has not violated international law by assuming control of the 27 aircraft stationed in its territory. If Your Excellencies have no preliminary objections, the agent would move towards the fourth issue.
So please carry on.
Much obliged, Your Excellency. The fourth issue before this Honorable Court is that Gantaland cannot challenge the award of the Arbitral Tribunal before the ICJ, and there are 3 prongs of arguments in this regard. Firstly, the ICJ does not have the jurisdiction to entertain the case, as arbitral awards are final and binding in nature, and the doctrine of res judicata would be applicable in the instant case, Your Excellencies. Furthermore, Your Excellencies, as per the principle of forum non-convenience, ICJ is not the right forum to approach in the instant case, Your Excellencies. Thirdly, the award is enforceable as per the New York Convention and the exhaustive grounds enumerated under Article 5 of the New York Convention. At the outset, Your Excellencies, the agent would make a humble submission in this regard, as the applicants misled the court by saying that Article 5 of the New York Convention would not be applicable. Your Excellencies, the humble submission is that Article 5 provides with the only enumerative exhaustive grounds for challenge of the arbitral award, Your Excellencies, and both the parties are in fact parties to the New York Convention, and hence it is very well applicable in the present case, Your Excellencies. With your permission, the agent would elaborate the limbs of the contention.
Yes,
Much
please.
obliged, Your Excellency. Final arbitral awards have a preclusive effect, Your Excellencies, and the principle of res judicata would be applicable here, as it emphasizes upon the final and binding nature of the arbitral awards, rendering it unchallengeable, and as such, they also have a preclusive effect. And violating this principle of res judicata, Your Excellencies, would be an abuse of process, contravening the good faith principle which the respondents hold very dear to. Therefore, the arbitral award in favor of the state of Parzival is final and binding in nature and is not subject to challenge before the ICJ. Further, Your Excellencies, moving to the next sub-issue of the first limb, ICJ is not the appropriate forum under the principle of forum non-convenience. ICJ can in fact decline jurisdiction if there exists a statutorily more appropriate jurisdiction. And Your Excellencies, as per Article 5, Clause 1, Subclause E of the New York Convention, the competent authority to decide the challenge is the domestic court of the enforcing country, which is the domestic court of the state of Gantaland and not the ICJ, Your Excellency. Your Excellencies, additionally, it was held in the Guinea-Bissau judgment and the challenge of the arbitral award made by the Kingdom of Spain in the year 1906 that the ICJ cannot proceed on merits and the ICJ cannot decide as to whether the arbitrator's decision was right or wrong, as ICJ is not an appellate forum, Your Excellencies. So any deviation of this rule is an abuse of process, Your Excellencies, done by the applicants in the present case. Moving on to the second limb with the permission of Your Excellencies. Much obliged, Your Excellency. The award is enforceable and unchallengeable as per the New York Convention. Firstly, the award does not fall within the grounds laid down under Article 5, Clause 1 of the New York Convention. As Your Excellencies, a proper notice was sent to the state of Gantaland, but it refused to participate in the arbitral proceedings as reflected in page 17, para number 28 of the compromise. Are Your Excellencies with me on this? Your Excellencies, page 17, para number 28 of the compromise.
Yes, please.
Wherein
continue.
it has been stated that the state of Gantaland refused to participate in the arbitral proceedings which were initiated against the state of Parzival, Your Excellencies. So the first ground under Article 5, which are the grounds of challenge, are not made out. Secondly, the matter was arbitrable in nature as the intent to arbitrate is clear, Your Excellencies, from the GPFTA, which has been signed by the two parties, especially Article 11 of the GPFTA, and Your Excellencies may refer to paragraph 11, page 11 of the Moot Compromise for this. Furthermore, Your Excellency, the award also does not violate the public policy of the state of Gantaland, as no sovereign rights have been affected as a result. In fact, the sovereign rights of the state of Parzival are at stake, Your Excellencies, as the process of renationalization which was effected by the state of Gantaland constitutes unlawful indirect expropriation, as substantially Parzival has been deprived of its managerial control and ownership over Gantaland Airlines, Your Excellencies. Cumulatively, it is submitted, Your Excellencies, in the proceeding that ICJ is not the appropriate forum in the instant case, and the state of Gantaland cannot challenge the arbitral award before the ICJ, as the award is final and binding in nature. Your Excellencies, the prayer is on record. If Your Excellencies may permit, I could move to the prayer.
Yeah, you continue.
Much obliged, Your Excellency. Your Excellencies, therefore, may it please the Honorable Court, in the light of the issues raised and the arguments advanced, that Gantaland committed genocide of the Sobriquet in its territory. Secondly, Parzival did not violate international law by assuming control of the 27 aircraft stationed in its territory. Thirdly, Parzival did not abuse their rights and duties by conferring nationality on Mr. Nolan Sorrento. And fourthly, the ICJ cannot entertain the challenge to the arbitral award as it is final and binding in nature, all of which is respectfully submitted by the respondents in this particular case. It was absolutely an honor arguing before this Honorable Court. Thank you so much.
Thank you very much.
Your Excellencies, we had reserved 2 minutes for rejoinder.
Yes.
Your Excellencies, in my rejoinder, I just want to simplify the case and tell this court what our case is. On the 27 aircraft, what Parzival is simply saying is that if a corporation owns 100 aircraft and a shareholder has a 51% shareholding, that means that the shareholder can do what they want with 51 aircraft. That's simply not how corporations work. The aircraft are owned by the Corporation of Gantaland Airlines. If Air Parzival wanted, it should have gone to the board and then taken a resolution of the board to use these 27 aircraft. And as a respondent, it was on them to rebut this argument of expropriation and not bring up grounds of discrimination, etc., which were not even alleged by us, which is why their act of assuming control of the 27 aircraft was invalid. On citizenship, they said in their submissions that they had the right to make as many exceptions as they could. We are not contesting that. In municipal law, Your Excellencies know that a statute gives the executive the right to take decisions. The question is whether the executive took those decisions in light of the statutory scheme. Our simple submission is that while Parzival had the right to grant citizenship, the manner in which they granted citizenship was in extreme bad faith, amounted to an abuse of rights, and damaged Gantaland's economic interests, which is why their citizenship was an abuse of rights. Thirdly, On the
Excuse me, could you tell us what prevented you from going to for arbitration and representing yourself and raising all these issues there on merits?
Yes, Your Excellencies. Your Excellencies, the arbitral concerned with the investment-related dispute. Now, Gunterland did not participate in the arbitral proceedings because we believed that there was no dispute to begin with. What Parzival did was first acquire the 27 aircraft and then gone to the tribunal preemptively to declare that they had not violated the international law. It is unheard of in arbitration for a party which has itself conducted wrongful conduct to go to the tribunal to unilaterally seek a declaration that it has not violated law without the other party filing a counterclaim, which is why the grounds of public policy, etc. of Article 5 are simply irrelevant. And lastly, on genocide, as the respondents themselves said, innocent until proven guilty. It is Parzival which has to prove that Gunterland has committed genocide of the Sobrukai people by independently proving actus reus and mens rea. Merely saying that people died, merely saying that you have a discriminatory intent is not enough to sustain a criminal conviction. Your Excellencies know a criminal conviction cannot be based on mere conjecture. It has to be proved beyond reasonable doubt with a proper policy on conclusive proof. And that is a simple case, and it was an honor to argue before you. Thank you very much.
Thank you.
Thank you.
Your Excellencies, are we permitted for rebuttals?
Yes, you may carry on.
Much obliged, Your Excellency. Your Excellency, firstly, about the rebuttals raised by my learned friends about genocide. Your Excellency, we have independently proven the elements of actus reus, mens rea, and the dolus specialis, Your Excellency, and that was done by my co-agent, Your Excellencies. Secondly, Your Excellencies, no wrongful conduct, as quoted by my learned friends on the other side, no wrongful conduct was done by the state of Parzival, as due process was followed. And in a legitimate share purchase agreement between Mr. Sorrento and the state of Parzival, the sale of aircrafts was done, and subsequently the assumption of the control of aircrafts was done. In fact, the actions of the state of Gunterland of renationalization, which has not been addressed in the rebuttals at all, Your Excellencies, is in fact unlawful indirect expropriation, as it has been done in a malified manner and, Your Excellencies, in an illegitimate manner, Your Excellencies. That are the humble submissions in this regard, Your Excellency.
Thank you.
Thank you.
Yeah.
I request the audience members and the participants to please remain seated. We shall be commencing with the valedictory function shortly. Shri Justice Kamal Khata, Shri Justice Arif Doctor, trustees of the DM Harish Foundation, senior counsels of the Honorable Bombay High Court, the dignitaries and luminaries who have graced us with their presence this evening, Madam Principal Dr. Asmita Vaidya, Professor Nuzhat Sheikh, Professor Kishu Daswani, and ladies and gentlemen. To begin this evening on a solemn note and invoke the Almighty's blessings, I would request the dignitaries to come forward and light the lamp.
अभय जाड्यांधकारापहा प्रदां शारदा
Thank you so much. DM Harish Memorial International Online Moot Court Competition is jointly organized by Government Law College, Mumbai and the DM Harish Foundation, a trust instituted in the memory of India's one of the most eminent jurists, Mr. DM Harish, an alumnus of Government Law College, Mumbai, and an authority on income tax law. With an heritage spanning a century and a half, Government Law College, Mumbai has dominated the legal landscape of India since its inception in 1855.
This competition was the first international moot court competition in India and has since emerged as the most prestigious mooting competition of its kind in the country, playing an important role in the promotion of mooting in the country by providing a platform for law students to hone their advocacy skills. With teams from United Kingdom, the United States of America, Singapore, Mauritius, Spain, Greece, Ireland, Australia, Sri Lanka, Bangladesh, Nepal, and many other countries having participated in this moot court competition across multiple editions. This moot truly encapsulates a global spirit and experience. The 2023 edition of this moot saw over 30 teams from across the world, with 16 teams qualifying to the oral rounds of the competition. The case study for the competition, dealing primarily with issues related to public international law, was drafted by Dr. Amal Sethi, a senior fellow of the Faculty of Law at the University of Hamburg, and Sumit Chatterjee, an advocate at Arista Chambers, both having experience and expertise in the field of public international law. Our dignitaries for today were thoroughly impressed by the fine display of advocacy by the finalists.
We have amidst us today our Madam Principal, Dr. Asmita Vaidya, a university ranker at graduate and postgraduate level. With an MBA in Human Resource Management, she pursued doctoral research in industrial law and did her PhD in the year 2009. She started her career as a teacher at the Postgraduate Department of Law at Nagpur University in the year of 1995. Dr. Vaidya has chaired many technical sessions and delivered many lectures as a resource person on different legal topics such as cyber law, intellectual property law, human rights, women's rights, and surrogacy, to name a few. I would like to thank our Madam Principal, Dr. Asmita Vaidya, for the guidance and direction she has provided to the Moot Court Association and its functioning. I would like to request Assistant General Secretary of the Moot Court Association, Mr. Rajveer Veera, to felicitate Madam Principal.
Okay. Perfect. Please carry on. Please carry on.
I'm the host, sir.
I would like to invite Madam Principal to address the audience.
Saraswati Lavandan. Today's guest of honor and the judges in real sense of our competition, Honorable Shri Kamal Katha sir, Honorable Shri Arif Doctor sir, Trustee of DM Harish, Anil Harish sir. We do have Mrs. Shobha Jaktiani madam and Mr. Sharan Jaktiani sir, Professor in charge, all the other professors and my dear students, as well as the team were the participants all over the globe who are participating in this competition. I welcome you in this evening. I think this is a very energetic and enthusiastic evening for all of us because the time has come for the results. I must appreciate the efforts taken by my students throughout this journey of reaching in the finals. The whole MCA team, all the other students and professor in charge who have guided them very nicely. As has been communicated to you, that total 20 teams, they have approached us for this competition and 16 have actually participated. Out of 16, 3 are from they are from international level, that is from different countries, and all other they are from different corners of the Bharat. I really appreciate all the team members who have actually shown their interest in participating GLC's DM Harish Moot Court competition. Sir, as has been known to everybody, Government Law College is known as and is famous as GLC. And everybody comes here, rather strives to take admission here, and they do have that dream in their eyes to take admission over here. This is because GLC is known for the academic activities at national as well as international level. In the last year, we have conducted more than 100 academic programs. Based on only Indian Constitution, we have conducted 75 programs, and others were on different laws. Not only that, this year also, we have conducted many of the program, one of which is dominating one is a Marathi drama called Madhura, which I think focuses on the importance of Marathi language. Why I'm telling this, it is only because not only academic, but we are also ahead in different fronts. We could manage this only because our students are very enthusiastic, very cooperative. Not only that, they are ready for every kind of assignment which is assigned to them. Even our professors, like Kishudaswani, he is always with us for guiding our students. This college is known not only because of this, but also because this college has given many social reformers, freedom fighters, social workers, eminent judges and the lawyers, and the teachers to the society. Earlier, this college used to run only 2 programs, 3 years LLB course and 5 years LLB course. But from this year, GLC has started, this year we have started a LLM course also and a research sale for our students. So the one student takes admission for the LLB program, he will be out only after getting his doctorate, and he will be known in the society as Dr. So-and-so, along with advocate.
Yes.
Along with 5 years course and 3 years course, we have also started 5 short courses, which are called as add-on courses. At entry level, we have certificate course in communication skill. In second year, we have certificate course in Digi Law, which mainly focuses on the e-filing and e-courts. For third year students, we have certificate course in ADR. At fourth year level, we have certificate course in trial education, and exactly which we are talking about and discussing about the advocacy skill and the professional ethics. Based on that, we have certificate course in advocacy skill for the final year students. So all these courses, they are designed only for the GLC students. And therefore, I think the moment, that is my dream, that the moment they will be out, they should be well equipped with everything. So with that intention, we have started these add-on courses. I am very happy that most of the students and different teams, that is 16 teams, have participated in this competition. As you all know, this is the 24th year of the competition, and we cannot have this competition without the support of Harish Foundation, DM Harish Foundation. And therefore, I think we must put together our hands for appreciation. And most importantly, every competition must be judged. And I think Honorable Justice Kamal Katha sir and Honorable Justice Dr. Sir, that is Arif Dr. Sir, they are always with us. And our students always, whenever I ask them to whom you want to ask, to whom you want to approach, they say, we are going to approach these two first. And the moment they get the consent, they are very happy, because they are very sure that the competition will be successful. So I really express my gratitude for giving your time, sir, to our students as well as GLC. With these words, I appreciate and congratulate the participants and the winner. And most importantly, I also congratulate all the MCA team members. A big applause to them for their efforts for making this competition successful, particularly Sakshi, and I will name all. Okay. So thank you very much.
Thank you, madam, for those words of wisdom. The trustees of the DM Harish Foundation have, over the years, established a bond with this college which goes just beyond this competition. Mr. Anil Harish, Mrs. Shobha Jagtiani, Mr. Harish Jagtiani, Mrs. Harish, and Mr. Sharan Jagtiani have always provided the Moot Court Association with unwavering guidance and support through all its endeavors. I would now like to request the General Secretary of the Moot Court Association, Ms. Sakshi Shetty, to felicitate Mr. Anil Harish. I would request Mr. Anil Harish to kindly address the audience.
Honorable Judges of the Bombay High Court, Principal of Government Law College, Dr. Asmita Vaidya, Professor Sheikh Nusrat, and Professor Kishu Daswani, and other distinguished professors, fellow lawyers, ladies and gentlemen, and my fellow students, because we must remain students all our life. From the National Law University of India to Northumbria, from Mumbai to Mauritius, and from Bhopal to Bangladesh, this year's competition has seen wonderful rivalries in the best spirit of the law. Your Lordships, Honorable Mr. Justice Kamal Khatta and Honorable Mr. Justice Arif Doctor, thank you so much for having fixed a special hearing with only this matter on board, and for having given so much time to studying the matter and for having asked incisive questions. It elevates all of us to be in your presence and to see what you do in the cause of education and for society. We are indeed grateful. I am also grateful to all the senior advocates and other lawyers who have so willingly judged the teams and grilled the students. They too have given so much over the years to the Moot Court competition. And we see at a time like this how difficult it is to be judges and to decide between sides who are so often very closely matched. Accordingly, all the lawyers took voluntary retirement from judgeship earlier today and respectfully gave way to the higher court of your lordships. This is what makes anything to do with education so extraordinary and so satisfying, to see how many participate in this great cause and give of themselves. We are very glad the teams from so many universities across India and from overseas have participated in this competition. And we have seen the depth and breadth of the knowledge of the young students and their fluency and articulateness, and how hard they have had to work to argue a case like this. My compliments to all the participants. I hope they have enjoyed the learning and the arguments. We missed the Oxford University team this year. They had won the competition last year, but had to pull out at the last minute on account of the illness of a member of the team. I am very grateful to the principal, Dr. Asmita Vaidya, and to Professor Sheikh and Professor Kishu Daswani and other professors who have guided the students and have always been there for the MCA. In addition, there are so many professors of the other participating teams who have mentored their teams, and I'm very grateful to them. I do appreciate also those who have judged the memorials submitted by the teams, namely Danish Nethani, Ridhima Karya, Arzin Ansari, Kunal Kataria, and Uttarsh Srivastav. Everyone who has witnessed the competition will justify to the dynamic nature of the law. The same set of facts and law have been addressed in completely different ways by the student advocates representing the applicants, and then at different times representing the respondent. And their arguments have been shaped by the questions posed by the judges. It is no wonder that life in the law is such a thrilling experience. The case was very well drafted by Dr. Amal Sethi, Senior Fellow at the Faculty of Law, University of Hamburg, where he teaches and researches on constitutional law, and also by Mr. Sumit Chatterjee. All the participants have learned a lot, but I'm sure they have also spent many sleepless nights thinking about the issues. And now I'm sure that the participants know that they have Dr. Sethi and Mr. Sumit Chatterjee to thank for those sleepless nights. The Moot Court Association, headed by Ms. Sakshi Shetty and comprising more than 20 members, has been, as always, wonderful, right from planning the entire program, preparing the bench memorials, and attending to other details. All of you are truly special. Thank you. George Bernard Shaw said, "It is the duty of each one of us to ensure that the candle burns more brightly when we pass it on than when we received it." Your Lordships, Principal, Professors, Advocates, and friends, thank you for doing just that. Thank you.
Thank you so much, sir, for those thoughtful words. We have with us Honorable Shri Justice Kamal Khata, who presided over the final round of oral proceedings for today. He did his schooling from Mahindra Students Academy and completed his BCom from HR College of Commerce and Economics. His Lordship studied law at Government Law College, Mumbai, and graduated in law from KC Law College, Mumbai. His Lordship has appeared in matters related to company law, property law, testamentary law, admiralty law, arbitration law, trademark law, writ petitions, and public interest litigations. Conducted arbitrations both as an arbitrator and a counsel. His Lordship was appointed as the Additional Judge of the Bombay High Court in the year 2022. I would like to invite our Madam Principal, Dr. Asmita Vaidya, to felicitate Honorable Shri Justice Khata.
Thank you.
I would like to request Honorable Shri Justice Kamal Khata to address the participants.
Good evening, everybody. Good evening, Mr. Anil Harish, Dr. Asmita Vaidya, my brother, RF Doctor, my friend, Sharan Jagtiani, and Mr. Jagtiani and Mrs. Jagtiani here, who are present here as a family and are supporting this DM Harish memorial thing. Now, this is the third time that I have come here in almost 6 months, and I'm pleasantly surprised that the manner in which the students are upping their game is amazing. This is probably the first time I have judged a moot court, which is virtual. So it was a phenomenal experience. I must say they did a fantastic job. And I see that they are really shaping up themselves for the next generation. We are looking at virtual courts, and probably we are looking at digitalizing things. And in this path, we as the next generation are really shaping up this thing very, very well. I think it was a phenomenal job of all of you here to have done this so successfully and beautifully that it was seamless. The way it all started and ended, it was absolutely a seamless experience. Not many times do we see this in courts. In courts, we have so many difficulties where people are, looking out for papers, we are asking things, and it's all a jumble-gumble. But here, it was so seamless and so beautifully done that I must appreciate the efforts of all who have really done everything here to make it so seamless and wonderful. So congratulations to all of you who all have done it. I think all the participants fared exceedingly well, at least for us. When we heard and judged this moot court, it was so very, very difficult for us to decide, who is done better, who is not, what is the question to be asked. They were so good at their facts, their law, their alertness that we were pleasantly surprised. I must say that students here are really taking a lot of effort in really participating. And I'm very happy that our next generation is participating. And I hope that we have more moot court competitions, especially, and these kind of international moot court competitions, which would definitely give a lot of advantage for the students to think global. We are only thinking about Indian laws, but this effort of DM Harish Moot Court Competition has brought us on a different platform. We are going above and we are thinking beyond the Indian laws, which is a very, very crucial and important aspect. Because once we think globally, we know that we are citizens of a universe, of a world, not only an Indian, and we don't think like a frog in the well, but we think beyond our jurisdiction, which is very good. It brings about a different kind of thought process. And therefore, we are eager to learn more laws, and we see where our country can be improved by seeing these different laws, which is extremely, extremely good. I think the way this entire thing was judged, the way it was planned, the way it was completed was fantastic. I must congratulate all the members of the Moot Court Competition committee who has really set up this whole thing. Wonderful job. I must also say that all the students here must try to at least analyze these very booklets which you get. If not, at least try to again read them and analyze them. So give it a thought as to what could have been argued, what could have been done, to give it a thought process. It is not just a moot court competition. It's a learning process. We are the present, but you all are the future of the country. So it is important for you to create a thought process which will help you to become good lawyers. And these competitions itself are going to help you do this, so that you will be agile, you'll be knowing the law, you'll be researching, you'll be thinking, and which is what is needed to become good lawyers. Assuming you don't take up law and as a practice, even in the corporate sector, this is certainly going to help you because you'll analyze and think. The first and the most important thing is the first letter that goes into the legal system, and which is important because that's what you're going to draft. So unless you think and think globally, you will never draft your first letter importantly, and which is what is going to help you. So please, I'm very, very grateful that all you guys are here on a Sunday evening and you have taken that trouble to come. Very, very nice. Congratulations to all of you, and congratulations to all the teams here who have participated. Thank you very, very much for inviting me here. Thank you.
Thank you, Your Lordship, for those encouraging words. It is my pleasure to introduce Honorable Shri Justice R.F. Doctor. He has completed his schooling at the St. Mary's ICSE School and graduated from St. Xavier's College, and then gone on to pursue law at Government Law College, Mumbai. His Lordship enrolled as an advocate with the Bar Council of Maharashtra and Goa in the year 1998 and joined the chambers of Senior Advocate Mr. Darius Khambata. His Lordship has practiced in civil, constitutional, and public interest matters, including those pertaining to the enforcement of environmental laws. His Lordship appeared extensively for the Maharashtra State Human Rights Commission in several matters and also appeared as an arbitrator in several arbitrations. In addition to practicing in the Honorable Bombay High Court, Justice Doctor has also appeared before the Honorable Supreme Court of India and various tribunals and commissions, including the National Company Law Tribunal and its Appellate Tribunal. His Lordship was elevated as an additional judge of the Bombay High Court in the year 2022. I would now like to request Mr. Anil Harish to felicitate Honorable Shri Justice Doctor.
I would also like to call on stage the Assistant General Secretary, Rajveer Veera, to felicitate our Madam Principal. We shall now begin with the most awaited segment of today's evening, the declaration of results. I would request Madam Principal, Dr. Asmita Vaidya, to announce the award for the second best memorial.
It's my pleasure to announce second best memorial team. Team code A, National Law University, Odisha. Thanks to the team.
Thank you so much, Madam Principal. I would now like to request Mr. Anil Harish to announce the award for the best memorial.
The winners of the Best Memorial Award are Team Code K, National Law School of India, University, Bengaluru. Congratulations to them.
Thank you so much, sir. I would request Honorable Shri Justice Doctor to announce the award for the best speaker and the second best speaker.
Award for the best speaker goes to Shaurya Gupta from Symbiosis Law Pune. The second best speaker goes to Braxton O.C. Bonsu from Northumbria University.
Thank you, Your Lordship. I would now like to request Mr. Anil Harish to announce the award for the best speaker in the final rounds.
The best speaker in the final round is Manar Bansal, National Law School of India, University, Bengaluru.
Thank you so much, sir. I would now request Honorable Shri Justice Khata to announce the award for the best team and the runner-up team.
Sir. So I would first announce the second best team, because it is not second. It is just that we had to, it is a thin line for us to decide. But someone has to be second, but they are not second in any which way. They have done wonderfully, and I must congratulate them for everything they have done. So the second best team goes to Team Code P, Rajiv Gandhi National Law University. Congratulations to them. The best team goes to Team Code K, National Law School of India. Yes, congratulations to them too.
Thank you, Your Lordship. Congratulations to all the winners. I would now like to call upon Ms. Sakshi Shetty, the General Secretary of the Moot Court Association, to deliver the vote of thanks.
Honorable Judges of the Bombay High Court, Honorable Shri Justice Kamal Khata, and Honorable Shri Justice R.F. Doctor, Madam Principal, Dr. Asmita Vaidya, Mr. Anil Harish, Trustees of the DM Harish Foundation, Professor Kishu Daswani, professors, participants, ladies and gentlemen. With the pandemic in picture for almost 2 years and a shift of activities to the virtual mode, it has truly been a privilege for the Moot Court Association of Government Law College, in association with the DM Harish Foundation, to organize this Moot Court competition with the final rounds in an offline setting, and in memory of the late Mr. DM Harish, GLC alumnus and one of the greatest taxation experts that India has ever seen. The growth and progress of this competition, first as a national level competition and later as one of India's finest international Moot Court competition, bears testimony to the constant support, encouragement, and dedication of a number of persons, and this competition would be incomplete without acknowledging them. I take immense pride to announce the 16 teams who qualified through the memorial rounds of this moot, namely National Law University Odisha, University of Mauritius, Gujarat National Law University, Government Law College Mumbai, Northumbria University, Bangladesh University of Professionals, National Law University Delhi, Lord's Universal College of Law, National Law Institute University Bhopal, National Law School of India University Bangalore, School of Law Christ University, National Academy of Legal Studies and Research, Praveen Gandhi College of Law, Symbiosis Law School Noida, and Rajiv Gandhi National Law University. The Moot Court Association of Government Law College will be ever indebted to Honorable Shri Justice Kamal Khata, who always supported and encouraged several of the Moot Court Association's endeavors in the past. And we once again thank His Lordship for his continued support and for consenting to judge in today's competition. I would also like to thank Honorable Mr. Justice R.F. Doctor for his invaluable time and for his prompt consent in judging the mooting grounds of this evening. We are indeed grateful to His Lordship for his cooperation and support. I would like to thank our Madam Principal, Dr. Asmita Vaidya, for his support and encouragement towards the mooting activities in the college throughout. This prestigious event is truly an outcome of the broad vision of the DM Harish Foundation. I take this opportunity to thank all the trustees of the foundation, and in particular, Mr. Anil Harish, Mrs. Shobha Jaktiyani, and others, for their steadfast faith and support in the Moot Court Association. I extend my heartfelt gratitude to the other trustees of the foundation present here this evening for their persistent belief in the association. I would also like to thank all the members of the legal fraternity, the advocates, senior advocates, and professors who promptly consented to judge the preliminary and the quarter-final rounds of the competition for this year's edition. I would like to thank Mr. Harish Jaktiyani, Mr. Janak Dwarkadas, Mr. Sharan Jaktiyani, Mr. Pradeep Sunchetti, Mr. Rohit Kabadia, and Professor Kishu Daswani for readily consenting to judge the semi-final rounds of this competition held this morning virtually. I would also like to thank Danish, Radhima Keria, Arzeen Ansari, Kunal Kataria, and Utkarsh Srivastava for painstakingly judging all the memorials of this year's event. I would like to thank Dr. Amal Sethi and Mr. Sumit Chatterjee for promptly consenting to draft the moot compromise for this edition. I would also like to thank Ms. Vidula Barze and Ms. Drishti Padrawala for drafting the bench memorandum of this edition. Professor Kishu Daswani and Professor Nazar Sheikh's contribution and significance to the Moot Court Association is hard to express in a few lines. Their commitment and continued support to the MCA goes a long way in ensuring success in all of our endeavors. I would also like to sincerely thank Mr. Adhiraj Harish and Ms. Rishika Harish for all their help in making this competition a success. I would now like to thank the members of the Moot Court Association for their constant devotion towards the success of this competition and their vital contribution in making this competition a reality. In particular, I would like to thank the post holders of the Moot Court Association, namely Rajveer Veera, Lubena Satarwala, Anushka Mani, Muskan Dadia, Shreya Bora, Drishti Patrawala, Agastya Vijay Raghavan, Karan Nair, Nikhil Pradhan, Vidula Barze, and Nishtha Gada. I would also like to extend my heartfelt gratitude to all the former MCA members for their constant cooperation, contribution, and support to the Moot Court Association. Lastly, I would also like to thank the entire staff of the Government Law College, Mumbai for their never-ending guidance and support throughout the year. In particular, I would like to thank Mr. Pradeep Jadhav and Mr. Ajit Kher. I would also like to thank the Advisory Board of the Moot Court Association, Mr. Ruben Vakil, Mr. Shanay Bafna, and Mr. Feroz Patel for their constant support and guidance. I would like to extend my heartfelt gratitude to all the participating teams, both domestic as well as international, for participating in this edition of the competition. I hope this was an enriching and enjoyable experience and hope to welcoming you all again in the near future. Thank you and have a pleasant evening.
Thank you so much, Sakshi. To end today's valedictory ceremony on a patriotic note, I request everybody to please rise for the national anthem.
Adhinayaka Jayate Bharata Bhagya Vidhata Punjab Sindh Gujarat
With this, we hereby conclude the valedictory function of the 24th DM Harish Memorial Government Law College International Online Moot Court Competition. I request all the audience to please remain seated as the dignitaries are escorted.